On May 19, 2025, prosecutors in Michigan filed an assault or assault and battery complaint against 33-year-old Alexis Brown in the 14A District Court. She was ordered to appear for an arraignment and pretrial hearing on June 18, 2025, but she never showed. The court then set a show cause hearing for July 2, and she missed that one too. At that point, the situation escalated fast. A warrant was issued, she was taken into custody, and on July 14, she finally stood before the court for arraignment. Because probable cause was found and she had not posted bond, she stayed in custody. Just days later, on July 17, the Washtenaw County Office of Public Defender formally appeared on her behalf. But when hearing day arrived, Assistant Public Defender Lauren Pern was ready to help, and Brown made a choice that would shape everything that followed. She turned down counsel and decided to speak for herself.
Court calls the case of the People versus Alexis Brown.
Good morning, Assistant Public Defender Lauren Pern on behalf, well, not on behalf of Ms. Brown. We are the attorney of record on this case. When I did meet with Ms. Brown, she informed me she wants to represent herself.
Your name?
Alexis Brown.
All right. Is that correct that you want to represent yourself?
Yes, it is.
So, in this matter, Ms. Brown, I do have to inform you that the complaint in this case alleges that on or about June 8, 2024, location of 3001 Woodland Hills Drive in Pittsfield, Washtenaw County, State of Michigan, that you did commit the offense of assault and or assault and battery against a Latasha Browning. Do you understand what you're charged with?
Yes, I do.
That is a misdemeanor, punishable by 93 days in jail, $500 fine plus court costs. Do you understand the maximum penalties?
Yes, I do.
There are certain things that are fraught in self-representation in terms of understanding the Michigan court rules and in terms of the court procedure. You would need to understand that if you would like to represent yourself, that you would be held to the same standard as any other attorney.
Mm-hmm.
The court will not be assisting you in any fashion whatsoever. You understand that?
Okay, so the time that I served, don't that counts for the 93 days?
I'm sorry?
The time that I served already, don't that counts for the 93 days?
I don't know how much time you
I served 30 days already.
And if you serve 30 days, it may count. I'm trying to look at what your bond is on this case. What do you have a bond?
And then no contact with the victim as well.
And the monetary amount? 5,000, 10%, then it should count. Yes, ma'am.
And so I have a question. So when I was arrested, I wasn't actually told my rights. So ain't that against the law that you wasn't told your rights when you arrested me? Well, not you, but the officer.
I cannot.
You can't do nothing about it right now?
I
All right, I just want to state that.
I can't answer that.
I just want to state it.
All right.
Okay.
Stated.
It's on record, right?
What came next exposed one of the biggest traps in self-representation, being confident without fully understanding the rules. Brown raised a familiar argument. She believed her arrest was unlawful because officers had not read her Miranda rights. But that is not how Miranda works. The Supreme Court's decision in Miranda v. Arizona does not automatically invalidate an arrest just because those warnings were not given on the spot. Instead, the rule is narrower and far more technical. If police question a suspect while that person is in custody, they must first advise them of the right to remain silent and the right to an attorney. If they fail to do that, the arrest can still stand, but certain statements may later be excluded from evidence. And that is exactly why the judge could not step in and explain the law for her. Under Michigan's judicial conduct rules, a judge can help a self-represented person understand courtroom procedure, but cannot cross the line into legal advice. The moment a judge starts answering strategy questions, neutrality is at risk. So Brown was left facing a system that speaks in procedure while trying to navigate it without a guide.
So,
Okay.
what do you want this set for, ma'am?
I mean, Your Honor, we have no offer at this time.
Do you want it set for a trial, ma'am?
Sure, I guess. I guess
You want a jury trial or a non-jury trial?
it doesn't really matter.
Well, you've got to make a decision, ma'am.
If it gotta go to trial, then it gotta go to trial.
Okay. Do you want a jury trial or a non-jury trial?
It doesn't matter.
You have to make a decision, ma'am.
It could have a jury. Fine. That's fine with me.
By the time this episode was written, Brown's case was still unresolved. A final settlement conference had been set for October 17, 2025, with jury selection scheduled for October 20. Court records also indicated she still had not posted bond. Then the video pivots to a second proceeding, one that shows a different kind of self-representation problem. This hearing took place before Judge Kristen D. Simmons in Lansing's 54A District Court. On February 20, 2025, Judge Simmons entered an eviction judgment against Chase Carson and Amanda Wilson, ordering them to pay their former landlord nearly $10,000. They did not satisfy the judgment, and the landlord's attorney, Jessica Larson, tried to collect through wage and bank garnishments. Those efforts mostly failed because she did not have current employment and banking information. So on August 19, 2025, the court scheduled a debtor's exam, a formal proceeding where debtors are questioned under oath about their finances. What should have been a straightforward collection hearing quickly turned into something far more volatile.
Jury final settlement conference in this matter will be set for 17th, 2025 at 9 a.m. Jury selection in this matter, October 20th, 2025 at 8:30. Both of those proceedings are in person. Thank you.
So am I free to go? So why am I not free to go? If she just said she got a bond,
Pardon?
why am I not free to go? Why do I gotta serve time when I'm not even?
You have a bond on the case, ma'am.
So if I get my money, I can get out. But she just said it was no bond.
Post bond, you can get out.
So I'd rather post bond. So where do I go from here?
You need to post the bond.
Okay, what's the bond? Because you just asked her the same thing. Cause she said
5%.
it's $500.
Yes, ma'am.
Okay, so I'd rather post bond. Where do I go from there?
And you can go post bond.
Okay, thank you.
It's your fault, parenting. Your fault. You just like suckered me into that. You got up there and then just said, well, we're the attorney of record, but
Oh, we're starting off the morning with a series of bad decisions already. This is wonderful.
yeah, I know, but they're all by Kearney. The whole McDonald's thing and then this. And
This-
okay, let's try this one.
Judge Simmons ultimately reset the matter for September 4, 2025, ordering Carson and Wilson to appear in person and bring the financial records Larson had demanded. Court records later showed that, on the day of that scheduled hearing, Larson filed a certificate confirming the judgment had been satisfied. But the real lesson from both proceedings goes much deeper than the outcome. In Brown's case, she seemed unsure of what the hearing was even meant to accomplish, misunderstood how Miranda actually applies, and looked to the judge for answers the judge was legally forbidden to give. A defense lawyer could have explained the difference between an unlawful arrest and a suppression issue, evaluated whether any custodial questioning had occurred, and if warranted, filed the right motion. In Carson and Wilson's case, Carson especially appeared to misunderstand nearly every lane of the process, how to challenge a judgment, how to preserve the right to a jury trial, how to handle a debtor's exam, and how quickly a courtroom can turn against you when frustration becomes disrespect. An attorney could have helped him stay focused, follow procedure, protect deadlines, and avoid making the situation worse in real time. That is the larger warning here. Courtrooms are not built for improvisation. Rights can be lost through timing. Arguments can fail because they are raised the wrong way. And judges cannot rescue people from strategic mistakes without compromising their role. When someone walks into court alone, the biggest danger is not always the facts of the case. It is not understanding the system until it is already too late. If there is another courtroom clash worth breaking down, save it for the next one.
Mr. Carson, you can remove your hat. This is the court proceeding. Today was the date scheduled for a discovery or a debtor's examination. Were you able to complete your exam?
No, Your Honor. Mr. Carson refused to answer any of my questions. He said he's not going to play games with me.
What games are being played, Mr. Carson?
Well, Your Honor, when I was previously there, I received a verdict by you that I believe to be emotionally charged due to your frustration with my inability to complete the tasks of a lawyer. I attempted to get a lawyer through the system. They denied me. I had to show up last minute unprepared, and things didn't go my way. So I figured, I'll do the process. I'll try to appeal it. I go downstairs and I'm told I have to pay $200 and some to even have a chance to get a fair trial or verdict. I'm having one individual who was emotionally charged at the time decide what has to happen with me instead of a jury of my peers. And now I'm being told I have to produce all my financial statements, documents, vehicles, titles, all this. And I have no interest, time, or energy to continue this charade. I've lost several days of labor.
Let me stop you because I'm just getting updated on this case. This was a landlord-tenant hearing that I presided over. Did you demand a jury trial?
I'm sorry?
Did you make a demand for jury trial in the landlord-tenant?
I requested, yes.
You made was there a demand on
in written? I didn't put anything in writing. I did request the trial. I went downstairs and asked what my rights are, and they said to proceed any further past your decision, I had to pay $200 and some to even try. I did not have the money at the time, nor would I have it.
But sir, I asked you to let me get caught up. I'm trying to see if you have filed a jury demand. Let me also be clear. I don't make decisions because I'm emotionally charged.
No,
don't talk over me. Don't talk over me. Just because I won't let you run my courtroom does not mean that I am emotionally charged. There's order that will be set in the courtroom and you will not talk over people. You will present the evidence. I'm absolutely fair and impartial, and you then have the right to appeal my decision. Just because you disagree with the decision doesn't make it impartial, okay? And if you don't follow, there's rules in place that I don't set as to how you file such appeal. If the clerk's office told you what you needed to file to move forward with the appeal, then that's what you needed to do. But I'm going to make it clear on my record that I did not make a decision in this case based on any emotions. I have no reason to be emotional about your eviction, sir. I'm not being evicted. So if you keep talking over me, this is probably what you did the last time. It's try to cut me off. Yeah, and you're shaking your head. So that's not me being emotionally charged. That's me not allowing you to run my courtroom. You don't talk over people. You have a question.
Yes, I was just speaking and you cut me off, but I'll let I
run the courtroom.
Okay, I understand.
Did you notice that?
May I finish, Your Honor, please?
Yes.
Okay. At the time of the last proceeding, I interrupted you. I apologize. But the second or third interruption, you stopped me in the middle of my sentence and awarded them the decision. You know what? You were like, you know what? Decision for them. You didn't specify why. It was just an emotionally charged because you were frustrated with my inability to complete the tasks of a paid lawyer.
I have evictions every single week And the majority of my evictions are people who do not have attorneys. I don't know if you know that. Over 75% of our cases do not have attorneys representing them. I do not get frustrated with your inability to do the task of a lawyer. Where I will get frustrated and where I will not tolerate is if you think you're going to yell out or yell at the other party, yell at me, and you're going to act a fool in the courtroom, I will no longer allow you to be heard. Just because I cut you off and make a ruling does not mean that I ruled in their favor because I was frustrated with you. I was going to rule in their favor anyways because of the facts of the case. I was allowing you an opportunity to be heard. But when your opportunity to be heard becomes a hindrance to the procedure in the courtroom, then I have to terminate the hearing. And so if you want to proceed in any other manner, I don't know what your rights are now at this point as it relates to your right to appeal. You may have exhausted that time frame, but you're going to need to appear in person. I'm going to reset this since you refuse to comply with the court order to participate with the discovery proceeding, because this is an official proceeding. This is not your option. You have to participate in the proceeding because you have a judgment against you and the plaintiff has the right to figure out how they can recover on that judgment.
Can we
Do
speak?
you understand that? Yes, you may.
Well, we tried to tell her, like, the funds, we can pay them. Like, we have no problem with that. We tried to tell her the same thing.
What is the past due amount?
It's roughly somewhere in the ballpark of $10,000 with interest, Your Honor.
And
I asked him if they could make a payment in full, and he wanted to argue the merits of the judgment itself. I never heard an indication there would be a payment in full. If there's some sort of payment plan, I'm happy to discuss that once I get my questions answered, because they have made no efforts to make payment on this, never reached out. We've tried multiple different avenues for the information that we did have on where we thought they banked and where we thought they worked. So I would need answers to all of the debtor's exam questions, and then I'm happy to work out a payment plan. In the event of a default, then I can pursue other arrangements.
okay. Are you in a position to pay in full the past due amount?
I'd prefer a payment plan. I would like to see what the interest is and what the original charges are. I was never actually formally presented with any numbers, despite what she had just told you. Until we were physically served for this court date, I had heard nothing other than a couple of emails where they were denied requests to garnish.
Yeah, we haven't received.
That is literally the only thing pertaining to the case I have seen since I walked out of your courtroom, attempted to file for an appeal, and was told I had to physically come up with money to do so that I didn't have at the time. So I at no point was ever given a fair trial. I was given an opportunity to pay for one potentially, but I've received, like, the judgment is for, you gave them and rewarded them things they shouldn't have had. We weren't there.
If you disagree with the court's position, you have the right to appeal. You failed to do that. I also want to correct the record again. You did not properly file any demand for jury trial, although being advised on your first appearance of how you have the right to a trial and how to file such jury trial demand. You did not file a jury trial demand. So if you didn't get a trial, that was on you.